much a part of the fabric of this community, even 150 years later, 140 years later. So I hope you'll take time to get to visit. I appreciate the opportunity to visit with you, to visit with some of you individually, and look forward to working with you. If I can ever be of any assistance to you in Baton Rouge, I hope you'll reach out to me. I've really tried to take one of your commissioners back with me. He was very much instrumental when I first got into the legislature. We hated to lose him, but we hear good things about what he's doing. Again, thank you for being here. Welcome to Central Louisiana. Welcome to Alexandria. And I hope you have a great stay and a productive day. Am I supposed to call up Mike Tudor?
We're not taking any questions from the audience, Mike. So
thank you for that.
Send our best regards to the legislature and drive safely.
Thank you.
Next up, I'd like to bring up a Rapides Parish business leader, Mike Shelton, to introduce our next speaker.
Thank you, commissioners. Thank you, Commissioner Francis, for bringing this meeting to Alexandria. I think it's been 22 or 24 years since the commission's been here. Thank you to the staff of the Public Service Commissioner and all the commissioners. And I think we have two former commissioners. Y'all know Jay Blossman, but I think Charlie DeWitt's in the crowd. Is he still? There he is. He was a former commissioner, but also two-time Speaker of the House, and he's our guy. He's done more probably for Central Louisiana than any other politician in the history of Rapides Parish. So thank you, Mr. Charlie. And I'd like to introduce, Commissioner Francis was talking to me about the history of this hotel and what it meant to Central Louisiana. As some of you know, he's from Gina, which is right up the street. And he played football for the Gina Giants, and remembers, if you were here last night, coming to Alexandria, it was like the big city. He said it was like coming to New York City. And all of us that grew up here, this was a great place, and you'll hear more about it, but it's the cornerstone for Central Louisiana. So I said, I have a friend who is a historian for Central Louisiana, knows more about the history of Central Louisiana, but particularly this property. And I'd like to have him come up and speak about it, but he won't tell you this, so I will. His family actually owned this hotel at one time, and it was closed for many years, and they are the family that's responsible for bringing it back. So I'd like to introduce Mike Tudor.
Thank you, Mike. If it's okay, I'd like to sit. I have remarks that I've made sure don't go longer than 5 minutes and address the commission, if that's okay. Yes, sir. I apologize to my audience for, here, I'll hold it, for putting my back to them, but I'd rather address you folks. And let me say first about Mike Shelton. Wonderful guy, was very enjoyable representing him when he owned Popeyes. And he has his own stories, and sometime y'all need to get him to tell you about us accompanying Commissioner Strain to Havana, Cuba in 2015, and running into one of Fidel's sons and our conversation. And Mike and I knew then that when Cuba was fixed, it was going to be all about the money, isn't it always? But thank you, Mike. I also want to acknowledge that I've met 3 of the commissioners. Commissioner Kusan and I happened to work together as attorneys when I was trying to cure a piece of property that had been out of commerce for decades. And it was a lot of fun getting to know you, and you had a different nickname then, but that's another story. And Commissioner Campbell spoke with the Alexandria Rotary Club a number of times, and as a Francis Grevenberg, Charlton Lyons, Dave Treen Republican, which will tell you how old I am, I've always respected and enjoyed hearing your very articulate enunciation of your political philosophy. Always respected it. And then I discovered Commissioner Francis and I were in high school together. I was a Pineville Rebel, and he was a Gina John. And I was relating that I was on the basketball team, and the only brawl we ever got into was my last game as a senior at Gina, and it was a doozy. And I said, oh my goodness, I hope we didn't exchange blows. And he said, no, I just played football, but that was fun to have that memory, Commissioner. Okay, let me get into the history of this property. The Hotel Bentley opened in 1908, built by Joseph A. Bentley, a wealthy lumber businessman. The backstory is that in the era of 1880-1910, there was a period of rapid national economic growth. The giant inventory of southern virgin forest offered the building materials for this growth. Post-Civil War capital was scarce in the South, so wealthy northern entrepreneurs such as Joe Bentley came south, acquired land and timber rights, and built sawmills. So did the northern emigre Martin and Kellogg families, who remained and contributed to this community through present times. Okay, this is the backstory. Since Joe Bentley was a bachelor all of his life, an expensive country or urban home was out of the question. Instead, Bentley constructed this hotel, which would also contain his personal residence as a multi-room suite overlooking the river. No way Alexandria, with a 1910 population of 8,000 and a Rapides population of 41,000, would have predicted at onset a commercially sustainable hotel enterprise. But this building was his home too. The architect chose the Beaux Arts style, which you just look up and you see it. That's the style highly popular in the U.S. during this period. If you would walk into the lobby of the Capitol Hotel in Little Rock today, you are going to muse, this looks familiar, same architect as this Hotel Bentley. Walk into the lobby of the still operating Jefferson Hotel in downtown Richmond, ditto, same architect. The hotel was successful despite its immediate population base because it was without rival and served all of central Louisiana from Vidalia to Leesville. An economic and geographic fact often overlooked by outsiders who often judge us by city limit populations. And at the time of its opening, Alexandria was a hub of 5 different railroad lines which produced travelers and guests for this hotel. And since its 1908 opening, this hotel has been a visual and icon of this city and region. Parenthetically, an anecdote, when the hotel reopened in 1985, after one of its interregnums of being closed, my grandmother related how her father and she caught the Texas and Pacific Railroad from Garland up to Alexandria for the grand opening, and she showed me outside on the exact spot of the present balcony where she stood and watched the ceremony below in 1908. In 1935, the successor owner to Joe Bentley, J.W. Beasley, authorized and financed the 8-story connected Art Deco tower. This boosted the hotel capacity to 300 rooms. The general contractor was Tudor and Ratcliffe, each of those families operating independently their own construction companies 3 generations later here today. In the midst of the Depression, this project contributed our own local WPA-like construction boost. Mr. Beasley was seen as almost something as a hero and personification of continuing faith in the future of our community. There's an historic marker on the DeSoto Street below which describes the 1941 Louisiana military maneuvers. These maneuvers were some of the largest war games ever held in the United States. Because Alexandria was the center of these exercises, many high-ranking officers such as Eisenhower, Patton, Bradley, and Clark stayed at the Hotel Bentley and our ate and drank here. These guys would today easily recognize the mirror room and the lobby and the dining room as unchanged. Now, MacArthur never made it here as he was then Generalissimo for the Philippines. Of course, at that time, none of these officers had the fame which World War II brought to each. But to this day, local families have stories of interacting with these famous military leaders, plus their families, who accompanied them here in many instances. There's a beautiful home on City Park Avenue on the National Register, built in 1938. The owners gave me the permission, the Milton Ray home, whose back porch, there are pictures of Bradley, Patton, and Eisenhower smoking and drinking and socializing. Most of us are familiar and heard it firsthand of a local young man, Lee Stagg, dating George Patton's daughter here, and actually some favorable comments made by the Patton family about people they met here and our hospitality. Knowing that is why I have always resented the remark Patton makes in his opening soliloquy in the movie by the same name, and I'm sure some of you will remember what he said about shoveling something in Louisiana. Equally important to our local history were the surrounding camps of Polk, Livingston, Claiborne, and Beauregard, which hundreds of thousands of soldiers were trained for World War II. And it might be mentioned there were precedents during World War I here when thousands took training at Camp Beauregard in Pineville, now the State National Guard headquarters in fact, if not in name. The patriotic past of our community even extends to the Civil War, when Alexandria was known as a Union town, thanks to the personal lobbying of highly popular LSU President W.T. Sherman, which school was located in Pineville till 1869. Post-World War II, this historic property has had its times of struggle and even closings. The advent of drive into the front of your room Holiday Inn-like chains of the 1950s challenged almost all historic downtown hotels. And obviously, Alexandria did not enjoy the growth of Little Rock and Richmond. But today, thanks to the local entrepreneur Mike Jenkins and his excellent staff, this Beaux-Arts architectural jewel remains our community icon. Parenthetically, the Bentley's only road past owner, whose name I shall not mention, had himself painted on a horse in Roman Caesar attire on the lobby rotunda ceiling, which you can still see now, supposedly as Augustus or Tiberius. But given the history, somehow when I look up, I always see Nero or Caligula. The Bentley's only rival in-state hotel longevity is the Hotel Montleon in New Orleans. And like the Hotel Peter and Paul in Marigny and other such examples, Jenkins has created Hotel Bentley as an event destination venue. With the wealth now concentrated at the top in this country, unique properties such as this are sought after by the uber-rich for weddings and other celebrations, and renting a whole property like Hotel Bentley is part of the new marketing strategy. So, gentlemen, as you contemplate our state's important business today, be aware of 118 years of similar serious convocations within these walls. Perhaps channeling a little bit of Ike's great wisdom would serve you well. Thank you for this opportunity.
Catherine, we enter announcements now? Yes, sir. Oh, I'd like to recognize a good friend that came from, drove here all the way from Ball, Louisiana. The mayor of Ball, the mayor of the town that has the Moon Pie Festival, Gail Wilkin. Gail, would you stand up and give everybody a hand? And when I hear the word moon pie, that's the nickname that Foster Campbell gave to Moon Grappa. So that's another moon pie thing. And
that's a real good name for Moon Grappa.
And I'd like to also, in all seriousness, change of tone. This is the area of our past friend, William Earl Hilton, and his passing. And he was a great friend to so many of us. I know Shane may be here, there somewhere, but he was a great guy, and we all miss him. And there's Shane. Thank you for sharing your daddy with us for all these years. Thank you. That's all I have.
Any other commissioners have anything? Just go ahead.
Thank you, Mr. Chairman. Just two announcements. I want to thank the American Association of Black and Energy, ABE, as it's known, for hosting its 49th annual conference this week in New Orleans. ABE was started in 1977 when individuals who worked at energy companies decided they needed a seat at the table to ensure that we were looking at promoting and pursuing opportunities for generation expansion, technology advancement. And so this week we were proud to have Abe here in New Orleans. I want to thank Entergy for being one of the lead sponsors and having so many of their staff participate in this conference this year, as well as Atmos Energy, who had a very large presence. I know majority of them are still playing golf right now at the annual golf tournament, but I'm here to do the people's business, so I just wanted to send a shout out to Abe and thank them for choosing New Orleans as the host for their 49th annual conference this week. The second announcement that I wanted to do is thank NARUC's President Ann Rendall. Recently, President Rendall appointed me as the co-vice chair of the Consumer and Public Interest Committee. I am deeply honored to serve our association in that role. I look forward to working with our new chairman, Commissioner Zenon Christodoulou, and my fellow co-vice chair, Commissioner Christy Nito of Wisconsin. And I look forward to showcasing what Louisiana does to protect consumers with our friends and comrades across the nation in NARUC. That's all I have, Mr. Chairman. Thank you.
Thank you. Commissioner Campbell, you have anything?
I'm glad to be here today. I have two special friends. My wife's uncle was Camille Gravel, who was a renowned lawyer in Louisiana, lived here in Alexandria. And my cousin was Ned Randolph, who was a previous mayor of Alexandria. So every time I come here, I think about those two people who are very proud of Louisiana, very proud of Alexandria. And it's glad to be here in their presence. Thank you.
Great. Well, thank you very much. Look, we're going to go ahead and jostle the agenda a little bit. We're moving one item up to the beginning. Catherine, you want to explain that, or at least list what that is for the agenda and do the NRA? And Commissioner Kuson has a directive, or is it a motion or direct? Directive, go ahead.
Yeah, so we're going to move Exhibit 16
You might
up.
have to speak closer to the microphone, I think.
Let's see. So we're going to have to, we're going to move Exhibit 16 up for, we're going to keep the executive session to the end of the session, but we're going to move up the directive from Commissioner Kuson, which, Commissioner, would you like me to go ahead and read it?
Yeah, would you please? Thank you.
So it's the directive to staff to open a rulemaking to evaluate private use electrical networks at the request of the Vice Chairman. A Louisiana State Senate Task Force created Senate Resolution 195, and it's been studying inter alia policies regarding energy self-generation, industrial microgrids, and expedited permitting in the state of Louisiana. Discussion at the task force also included potential statutory changes to ensure that Louisiana has the electrical generation needed to attract new large loads to Louisiana, and more recently, how microgrids could serve these large loads. Incidentally, Senate Bill 490 has now been introduced into this 2026 regular session, proposing private use electrical networks to enable construction of generation to support large industrial and digital infrastructure projects. The Commission is actively participating in those task force meetings, and has provided pertinent information garnered from relevant prior Commission rulemaking proceedings, including its position memorialized in docket number R35462, that certain situations created by some utility customers could create stranded costs and the potential for increased costs to all other customers. Nevertheless, private use electrical networks was not directly addressed in docket R35462 and should be given due consideration. As the agency with the constitutional mandate to regulate electric public utilities, I direct staff to open a docket to evaluate private use electrical networks to enable generation to serve new large load looking to locate in Louisiana. I further direct staff to work with the already retained counsel and consultant in docket R35462 under their remaining budgets therein. And that is the
opposition to the directive? Hearing none, it moves forward. Please notify Executive Secretary Fry, please. And we'll go ahead and move forward with the regular docket.
So then moving to exhibit number 2, which is docket number T37136. This is Cantium v. Rosefield Fouchon Operating, complaint against Rosefield for transportation and terminaling of crude oil as a common carrier without a tariff on file with the Commission at rates that are excessive, and request that Rosefield pay reparations. refunds and damages for charges above just and reasonable rates. It's a discussion and possible vote to rehear the Commission's jurisdictional determination of Rosefield pursuant to the 19th Judicial District Court's remand, and this was Exhibit 2 last month. Last month, the Commission provided notice that the Commission would consider whether Rosefield services were jurisdictional based upon the remand from the 19th Judicial District Court. That notice was triggered by the briefing schedule set at the Commission's December 2025 B&E and provided for in the notice of transcript availability filed on January 8th of 2026. The Commission thought it was clear that the opportunity for all parties to present their respective cases was set forth in that briefing schedule. In fact, the Commission directed the parties to file briefs on the issues raised by the 19th JDC. As was evidenced at the March B&E, Rosefield interpreted the Commission's briefing schedule differently and anticipated a hearing during the B&E. In order to provide the other parties the opportunity to respond to Rosefield's additional evidence, as well as adhering to the Commission's standard procedure for the admission of testimony and evidence, the Commission remands this proceeding back to the administrative law judge to conduct an expedited, narrow hearing limited to whether the Commission's finding of Rosefield as a common carrier be altered based upon the applicability of Louisiana revised statutes amended during the 2025 legislative session, specifically Act 458. In conducting such hearing, Rosefield will have the opportunity to present the anticipated testimony from the March B&E, with an opportunity for Cantium and staff to cross-examine Rosefield's witness and put on their own witnesses regarding this information. To be clear, the only testimony and evidence that is to be presented by Rosefield during this hearing is that which was already presented at the March B&E and any necessary rebuttal. As part of this remand, the Commission directs the Administrative Hearings Division to notice a status conference within 15 days from today to determine an appropriate hearing schedule, including any pre-filing deadlines as determined appropriate by the judge, with a recommendation back to this Commission no later than the October 2026 B&E. The ALJ's recommendation should not only consider any live testimony presented at the hearing, but should also consider the facts already established in the record, as well as all parties' briefs filed pursuant to the Commission's briefing schedule. It is the Commission's position that the additional briefing is unnecessary. However, in the course of the proceeding, should the ALJ determine additional briefing is necessary, it is within the ALJ's discretion to do order. Further, this remand does not alter the Commission's action at the March B&E directing Rosefield to work with staff to establish an escrow account for all payments made since October of 2023, as order number T37136 was not vacated by the 19th JDC, and the 19th JDC's stay has been lifted. This Commission has jurisdiction over Rosefield unless or until such order is altered, modified, or set aside by a court of competent jurisdiction. We do have 3 yellow cards on this item.
We'll go ahead and put a motion on the floor, but while we bring it up, the people who want to speak for the cards, move to remand this matter to the ALJ for the purposes established in the reading by the Executive Council for the collection of testimony under the constrictions. Seconded by Commissioner Campbell. And people who want to call the cards up?
Yeah, so we have 3 chairs, so if y'all all want to come up, it's Jamie Watts, Kelly Perrier, and Matthew Simone.
Okay. Can everybody in the back hear? Okay, good. Before y'all start, you understand that the process of what we've done, and so we're going to move the bulk of this to the ALJ for that hearing. So I'd like to, limit this to the necessary, whatever's necessary now, and don't want to cross that bridge 2 or 3 times. So thank you.
Yes, Chairman, thank you. Jamie Watts on behalf of Rosefield Fouchon Operating, and very briefly wanted to state Rosefield's position on the Commission's proposed action today. Conceptually, Rosefield does not oppose a rehearing to remand the jurisdictional determination to the administrative law judge, as long as that process is equitable to all parties, is not unreasonably restricted in terms of the parties' ability to offer and respond to witness testimony, evidence, argument, and briefing, and does not alter the existing record by removing anything previously admitted or proffered. Rosefield continues to oppose the Commission's requirement for escrow of retroactive and prospective payments to Rosefield by Cantium and/or Harvest in excess of 67 cents per barrel. Rosefield believes that requirement is unauthorized. It is premised upon the LPSC's threshold jurisdictional determination that Rosefield is a common carrier pipeline, and that jurisdictional determination is what is to be decided in the proposed remand to the ALJ. And for these reasons, Rosefield reserves all rights to make any objections as this docket continues. Thank you.
Canteen folks?
Matthew Simone on behalf of Canteen LLC. One comment we'll make is that we reserve the right to object to any evidence that would not be allowed in a remand under Louisiana law. That's all.
Okay, great. We've had a motion on the floor and a second. Any opposition? Hearing none, the matter is remanded and approved. Move to the next item.
And just one additional
Go
housekeeping
ahead. You
item.
need to speak into the microphone. I'm not picking it up myself.
One additional housekeeping item, an announcement from staff that Ms. Evans has.
Go ahead.
Lauren Evans.
Tap on it. There you go.
Lauren Evans on behalf
There
of
we
staff. Consistent with the March 18th, 2026 B&E, wherein staff was directed to hold a technical conference on the non-binding guidelines related to large load customers, staff will hold the technical conference on Thursday, May 7th at 9 a.m. in the Natchez Room. Since this technical conference is not being noticed in a docketed proceeding, notice of the technical conference will be posted on the Commission's website under News and Information.
Thank you.
What was that date again? I'm sorry, I missed that.
May 7th at 9 o'clock in the morning.
That's in the main meeting room? Okay.
Correct.
Okay, so
Okay. Next item.
moving, there we go. Moving to exhibit number 3, this is docket number T37772. This is the Commission versus All My Sons Moving and Storage of Baton Rouge regarding an alleged violation of the revised statutes and general order dated July 1, 1921 as amended by exceeding rates as outlined in the company's tariff dated October 11, 2017 while operating under Common Carrier Certificate number 7508-A. Allegedly have occurred on or about June 27th of 2025 is a discussion and possible vote on a recommendation of the administrative law judge. Staff investigated All My Sons Moving and Storage of Baton Rouge following a customer complaint and determined that All My Sons had exceeded its tariffed rates for the move. Staff issued a citation with notice of the citation published in the Commission's official bulletin, and All My Sons did not appear when the matter was called for hearing. Staff argued that All My Sons violated the revised statutes in the Commission's general order and sought an order finding All My Sons guilty as alleged, fining the company $1,000 and assessing a $25 citation fee. The recommendation of the ALJ was issued on March 26, of 2026. Based on the evidence admitted at the hearing in this matter, the ALJ recommends that the Commission issue an order finding All My Sons guilty of violating Louisiana Revised Statute 45168B1 and the 1921 General Order by exceeding the rates in its effective tariff on file with the Commission dated October 11th of 2017. All My Sons shall pay a $1,000 fine pursuant to the revised statutes for said violations, and All My Sons shall pay a $25 citation fee pursuant to the 2006 General Order with all fines and fees due within 30 days of an order's issuance date.
Move to accept staff recommendation by Scormetto. Any seconds? Second. Second by Commissioner Kusan. Any opposition? Hearing none, so ordered. Next item, please.
Exhibit number 4 is docket number T37747. This is the Commission versus Too Easy to Move Moving Services regarding an alleged violation of revised statutes by engaging in activities relating to moving household goods prior to complying with the requirements of Louisiana Revised Statute 45164E and general orders dated March 16th of 2021 and April 3rd of 2008 as amended. Is a discussion and possible vote on a recommendation of the administrative law judge. Staff investigated the company and determined that it was advertising for intrastate household good moving services while not registered with the Commission. Staff issued its citation in 2025 with notice being published in the Commission's official bulletin. The company did not appear when the hearing was called. Staff argued that Too Easy's advertising for household good moving services violates the revised statutes and the general orders by holding itself out as a household good mover without being registered with the Commission, and further violates the Commission's general orders by failing to include a LPSC certificate number in its advertising. Staff sought an order finding that the company be found guilty, be fined $1,000, be ordered to pay a $25 citation fee, and all payments due within 60 days. The ALJ's recommendation was issued on March 9, 2026, and based on the evidence admitted at the hearing, the ALJ recommends that the Commission issue an order finding Too Easy to Move Moving Services is guilty of violating revised statute 45164E1 by engaging in activities related to household good moving advertising online prior to complying with the requirements of the revised statutes in the Commission's general order. is guilty of violating the Commission's general order by failing to include its certificate number in the online advertising. And based on these violations, based on these violations, shall pay a $1,000 fine pursuant to revised statutes in the general order and a $25 citation fee, and that all of these shall be paid within 30 days of issuance of the order.
Chair moves to accept staff recommendation. Any seconds? Seconded by Commissioner Kusan. Any opposition? Hearing none, so ordered. Next item, please.
Exhibit number 5 is docket number T37748. This is the Commission versus NOLA moving on an alleged violation of order number T37118 and revised statutes 45-161 and 180.1 by engaging in activities related to moving household goods prior to complying with the requirements of 45-164E and general order dated March 16, 2001, and failure to comply with the requirements of general order dated April 3, 2008 as amended. It's a discussion and possible vote on a recommendation of the administrative law judge. Staff investigated NOLA moving following a complaint from a registered carrier and determined that the company was continuing to advertise for interstate household good movings after being found guilty of advertising without commission authority in order number T37118, and NOLA had not paid the fines and fees required from that order. Staff issued a citation to the company with notice of the citation being published in the official bulletin, and NOLA did not appear at the hearing when the matter was called. Staff argued that the company failed to pay the fine and citation fee required by order number T37118 was a violation of that order, and arguing further that NOLA's continued advertising violates the revised statutes and Commission's general order by holding itself out as a household goods mover without being registered with the Commission and violating the Commission's general order. Staff sought that the company be found guilty as alleged and that the Commission enforce the payment of the fines and fees ordered in order number T37118. The recommendation of the administrative law judge was issued on March 16, 2026, and based on the evidence admitted at the hearing in this matter, the ALJ recommends that the Commission issue an order finding NOLA Moving is guilty of violating order T37118 for failing to pay the $1,000 fine and $25 citation fee ordered therein, that the company violated the revised statutes by engaging in activities related to household goods interstate through online advertising prior to complying with the requirements of the revised statutes and the Commission's general order, that they're guilty of the Commission's general order by failing to include a Commission certificate number in its advertising, and as such shall pay a $2,000 fine pursuant to revised statutes for the violation of the said revised statutes in the general order, as well as pay a $25 citation fee, and that these fines and fees shall be paid within 30 days of issuance of the order.
Question from Commissioner Kusan.
Yes, sir.
First, I'd like to make a motion to accept the staff recommendation.
Seconded by the chair. You have any questions?
So it's a general question for Ms. Burrell. I believe you are, could you please state what your role is relative to these investigations?
Yes, Commissioner. Jamie Burrell, on behalf of Commission staff. I'm a transportation administrator that runs the Transportation Division and oversees all aspects of transportation, including unregulated.
Thank you. Tammy, you're not getting done.
It seems like you're very busy.
I have been.
I've been getting a bunch of calls from constituents. Tap the mic. I think she's on now.
You know, I need to just bring it closer to you. I think these work a lot
Gotcha. Is that better?
better, way better.
Okay.
So I've been getting calls from constituents who are in the same industry as many of these entities who are subject to these enforcement proceedings. I take some of them with a grain of salt because they're competitors. However, in some cases, my constituents are pointing out that we have repeat violations. And in particular, exhibit number 5 is an example of that. What is the ultimate penalty? What is the worst penalty that we could enforce on a repeat offender under our current rules and statutes?
Our statute allows us to fine a carrier of up to $10,000 per offense. So it's up to $10,000 per offense.
And if they don't pay the fine, what is the teeth after that?
I have been working with counsel, and I will let Catherine Bowman answer that question.
Yes, so Commissioners, we can take our judgment and go to district court to enforce that order, essentially.
You can render it into a damage, a money judgment.
Correct. Yes, we could go after them to do that. We have not done that, but we can certainly look into that and start doing it.
Have we had instances where these entities are essentially starting new LLCs and avoiding the consequences of their prior names? Is that something that we're seeing in the industry as well?
I have seen them attempt to do so. If an owner of a company tries to come back in a different name, before I will grant the new authority, I will require them to resolve any issues in their previous company's name.
Before it's authorized?
Before authorizing a new company to come in. And that's across the board of all common carriers that we regulate.
Okay. And you said that you've experienced this issue?
I have on a few instances. I do have one right now that has a pending application. They've come in a new name, and they're having to resolve any issues they had under their previous name before I would grant a new authority.
Well, I support you in your efforts, and if we need to do anything relative to our rules to maintain that enforcement authority and to ensure that they're compliant, please let us know, and we'll look into it for you.
I'll do that, Commissioner.
Thank you.
I just want to add one other thing. We've discussed, I think, this in the past. The commission also has the authority to revoke their permit, correct, at some point?
That's correct, Commissioner, we do. And we do revoke permits if they don't maintain their insurance, they fail to make annual filings, quarterly filings. We have revoked authority for that. We could revoke authority for violating anything in the statute or commission orders.
Right, and if they fail to make payment on any fines, we could also revoke permits on that basis as well?
Yes, sir, that's my understanding.
Okay, and if permits revoked under one LLC, they couldn't start another one until they satisfied all the issues that were of concern to you?
That is correct.
Okay, thank you. Go ahead, Commissioner Lewis.
Thank you, Mr. Chairman. Ms. Burrow, just a quick question. I know we've talked about this. One of the challenges I've had in my district are those who are unauthorized operating. So has there been any conversations or things we need to do with the Secretary of State so as companies are filing their LLCs, they are advised that they should and must be registered with the Public Service Commission? Because I've had some of the same challenges in my district, I think, as Commissioner Kuson, but on the opposite, where they are pointing out operators who don't have a PSC permit in it.
I could most definitely reach out to the Secretary of State's office and see if there's anything that they provide to certain types of company, because they do have to identify themselves as to the nature of their business when they register with Secretary of State. Right. I most definitely can look and see if there's something that I could give to them that would trigger them referring them over to the Public Service Commission. I can look into that.
Great, and I look forward to working and helping with that, because that's been a challenge, not particularly on moving, but on some of the other transportation services that are regulated by us, where individuals are creating new businesses, great entrepreneurial, and then now finding themselves before us, even though they did not know they had to be registered because they were operating a business in their mind. So not only for the bad actors, but for those who don't know that they should be regulated by the Public Service Commission. So I look forward to working with you on that.
Yes, sir.
Great. Well, we have a motion and a second. Any opposition? Hearing none, staff, that matter is approved. Move on to, I think it's Exhibit 6.
Yes, sir. Exhibit number 6 is docket numbers I-37858, I-37860, I-37864, and a to-be-determined docket. These are Jefferson Davis Electric Cooperative, Dixie Electric Membership Corporation, Southwest Louisiana Electric Membership Corporation, and 1803 Electric Cooperatives request to initiate 2025 Integrated Resource Planning process pursuant to the Commission's General Order dated August 28th of 2024. It's a discussion and possible vote to hire an outside consultant. Staff issued an RFP to handle all 4 of these dockets. One, we received 4 bids. The first is United Professionals Company of $185,000 in fees and $4,000 in expenses for a total budget not to exceed of $189,000. The second is Christensen Associates Energy Consulting of $189,550 in fees and $4,000 in expenses for a total budget not to exceed of $193,550. Third is J. Kennedy and Associates of $189,000 in fees and $6,000 in expenses for a total budget not to exceed of $195,000. And the fourth is London Economics of $198,080 in fees and $7,712 in expenses for a total budget not to exceed of $205,792. Staff makes no recommendation as all four bidders are qualified.
Chair moves to accept the low bid, which is United Professionals for the amount stated, which is a total budget of $189,000. Any seconds?
A second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, so ordered. Next item, please.
Exhibit number 7 is docket number S37826. It's American Broadband Holding Company and CS Intermediate 2's Section 301M Notice of Transfer of Control of Cameron Communications, Cameron Telephone Company, Elizabeth Telephone Company, and LBH2 CSM Intermediate. It's a discussion and possible vote on a staff report and recommendation. On January 12th of this year, American Broadband Holding Company and CSM Intermediate jointly filed this request seeking an order of approval or non-opposition from the Commission to transfer ownership of certain ownership and control of certain American Broadband indirect wholly owned subsidiaries. The effect of the proposed transaction is the regulated Louisiana subsidiaries will ultimately be owned and controlled by CSM Intermediate. The request was published in the Commission's official bulletin and no interventions were received. Based on staff's review of the request submitted in connection with the proposed transaction, staff recommends that the Commission issue an order expressing its approval or non-opposition to the change of ownership and control of Cameron Communications, Cameron Telephone Company, Elizabeth Telephone Company, and LBH, subject to the conditions contained in staff's rec filed on March 19th of 2026.
Move to accept staff recommendation. Any seconds? Second. Seconded by Commissioner, I think that was Commissioner Francis. There we go. Any opposition? Hearing none, so ordered. Next item, please.
Exhibit number 8 is docket number U36697. This is Entergy Louisiana's application for approval of an alternative market-based mechanism process seeking to secure up to 3,000 megawatts of solar resources, including certification of those resources, expansion of the Go Green option rider, and approval of a new renewable tariff. It's a discussion and possible vote on Entergy certification filing for the Cypress Harvest Solar Facility. At the Commission's May 2024 Business and Executive Session, the Commission considered an uncontested stipulated settlement which was approved and memorialized in order number U36697. As part of that order, the Commission approved terms which govern the implementation of an alternative streamlined procurement process to secure up to 3,000 megawatts of additional solar resources or certification of those resources. Consistent with this process, February 9th of this year, Entergy filed the instant certification filing requesting Commission approve and certify a 200 megawatt solar facility in Iberville Parish. ELL provided how the facility complies with the break-even parameters and viability parameters established in the order, and filing further explained how Entergy anticipated allotting the requested program between the Commission-approved optional green tariff riders. Pursuant to the procedure established in the order, all interveners had an opportunity to file protests, and none did. On March 23rd of this year, staff filed the affidavit of Mr. Sissong pursuant to the review procedure established by the order, and based on that review, staff confirmed that Entergy has met both the break-even parameters and the viability parameters established in the order. Staff recommends that the Commission accept Entergy certification filing for Cypress Harvest Solar Facility filed on February 9th of 2026, and that the order is effective immediately.
Move to accept staff recommendation. Any seconds?
Second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, it's approved. Next item, please.
So Exhibit 9 is deferred, so we will go on to Exhibit number 10, which is docket number U37425. It's Entergy's application for approval of generation and transmission resources in connection with service to a single customer for a project in North Louisiana. It's a discussion and possible vote on a scope expansion for United Professionals Company. At the Commission's August 2025 B&E, the Commission approved a settlement between staff and Entergy regarding the approval of generation and transmission resources in connection with providing services to Meta Laidley. The Commission's approval was memorialized in order number U37425, and part of that approval contemplated additional capacity, specifically a need for additional capacity during the ramp-up period. Since order number U37425 was issued, Entergy has filed an application for approvals related to various purchase agreements. Part of that application indicated that the agreements would satisfy part of Entergy's obligation under order U34725 and address the needed capacity for the ramp-up period. Given UPC's knowledge and experience in not only the Commission's 1883 certification order, but the requirements of the order U37425, staff sought a budget expansion for UPC to assist with these filings. UPC submitted its proposed budget with discounted hourly rates. Staff recommends that the Commission increase UPC's budget due to a scope expansion for an additional $70,000 in fees and $2,000 in expenses for a total budget not to exceed of $72,000.
Move to accept the expanded budget recommendation of UPC by the chair. Any seconds?
Second.
Seconded by Commissioner Lewis. Any opposition? Hearing none, the matter is approved. Next item, please.
The next item is Exhibit Number 11, which is docket number U37794. This is SWEPCO's application for authorization of a system improvement plan, including related rate
The next one's
recovery.
yours.
It's a possible vote on interim rate increase pursuant to Rule 57 of the Commission's Rules of Practice and Procedure at the request of Commissioner Campbell, and this will need 2 votes. On November 24th of last year, SWEPCO filed the instant application, which was published in the Alliance for the Affordable Energy Intervened. On March 10th of this year, SWEPCO filed supplemental testimony to support SWEPCO's request that the Commission exercise its original and primary jurisdiction under Rule 57 to grant interim relief to extend its incremental vegetation management spending at the previously approved rate of $1.5 million per month for an annual total of $18 million. The recovery will be through SWEPCO's fuel adjustment clause from June 1st of 2026 through SWEPCO's requested system improvement plan in this docket. SWEPCO asserts that there is no overlap between the collection of the extended incremental spend and the collection of SIP cost. While staff makes no formal recommendation regarding the interim rate increase request, staff does note that pursuant to the applicable law, any interim increase should be subject to refund and the applicable bonding requirements. If SWEPCO's request is approved, staff would recommend that SWEPCO file proof of the applicable bond requirements with the Commission, be required to file an updated tariff within 30 days, and that SWEPCO cannot begin charging the interim rate until proof of the applicable bond requirements and updated tariff have been provided to and approved by staff.
Mr. Gillum and anybody from SWEPCO who wants to come up, Commissioner Campbell has some questions. Do you want to put a motion on the floor, Commissioner?
Well, we need to first do a Rule 57 motion.
I can't hear you, dear.
We need to do a Rule 57 motion.
Okay, move to bring the matter up under Rule 57 by the chair. Any seconds? Seconded by Commissioner Francis. Any opposition? Hearing none, the matter is approved for under Rule 57. Commissioner Campbell, you want to make the motion? Commissioner Campbell, you want to make the motion? Okay, he wants to talk first. Commissioner Campbell has some questions for you.
Okay.
You might have to bring that thing closer to him. There you go.
Tell us exactly what you're doing here.
He wants to know what you're doing.
What we're doing, Commissioner, is currently we have an incremental $18 million of vegetation spend that we've been doing for a while, and it will end May the 31st of this year. And we want to simply extend that $18 million that we're currently utilizing. And we've also filed for a system improvement plan. Once that plan is approved, the $18 million will drop off and we'll be into a system improvement plan.
You're worried if we don't do this today, there's a possibility about losing some workers, is that correct?
That's exactly right. We currently have contractors that are doing this work for us on property, and they know that that deadline's at the end of May, and so they're starting to look for other places to go do work. And because of the positiveness of this program, we recently had Winter Storm Fern, and tomorrow I'll be at SWEPCO 37 years, and it's the most positive response I've ever seen. When you look at the circuits that we've been able to work on with the $18 million incremental, we had 4 outages on the circuits that we touched, and we had 25 outages on those we've not yet gotten to. It's the best response I've ever heard and the best customer sentiment and the quickest recovery we've been able to do as a result of it.
Mr. Gillum, you have anything to add?
No, sir. Other than we'll be collecting $1.5 million a month, and then when the SIP is approved by the Commission,
It's not, so it's really not an increase, it's what we've been charging all along, is that correct?
Correct.
So I would like to make a motion that we improve this item.
Second.
Motion by Commissioner Campbell, seconded by Commissioner Kusan. Any opposition?
Yes, sir.
Go ahead. Commissioner Lewis.
Thank you. Thank you, SWEPCO, for coming and reaching out to my office. As you know, I'm a pretty stickler on interim rates, and I have a very hard criteria on interim rates. So I just had a few questions about this as we evaluate the SIP, your SIP program. So can you explain to me how the Commission will be able to verify that there is no overlap between intermediate recovery and your future SIP cost recovery, so that we're not having any double recovery throughout the process?
Yeah, what I would say, Commissioner, is as soon as that SIP is approved, the $18 million incremental that we're charging now, which is $2.91 a 1,000 kWh, will drop off and go away, and we'll be able to verify that through our reporting to the commission staff.
Okay, great. Thank you. I had a question, since we haven't fully reviewed the first interim 18 million, what metrics are you utilizing to evaluate the success of the program, since our staff hasn't had the ability to do that just yet?
What we've done, we've been able to look at those circuits that have actually been touched by the $18 million incremental and recorded SAIDI improvements on those circuits. So there's a fact base that the improvement is there because of that incremental on those circuits that we've been able to do the work on.
Let me, go ahead.
Yes, sir, thank you. And so can you, the potential customer impact of this interim recovery is not evaluated any differently than the monthly bill estimates that you just stated, Mr. Gillum, right? There's no bill impact that it would be contiguous?
No change.
It will stay the same.
It will stay the same, and that was about
will, yes.
$2.12, you said?
$2.91.
$2.91.
Yes.
That goes off.
$2.91. And so the last question I kind of have is, how will you really track the effectiveness of this continuation spending with what you're also asking in the SIP to showcase that there needs to be this kind of continuation of vegetation management spending, or then also an increase as you're asking within your filing in the SIP program?
Right. We use a third party to determine the SIP and calculated the cost that it would be, and did a cost benefit ratio on all the circuits that needed to be touched by a SIP, a system improvement plan, and anything with a cost benefit ratio of 1 or above, we identified those circuits. That's where we'll do the work, and then we'll have extensive reporting requirements to prove that out to the commission as we go forward.
Thank you. And are you planning, as you know, we approved the pilot vegetation management program that would be very separate from this, but I'm curious, are you also planning to file a plan under that pilot program that has been approved by the commission?
No, we're not going to do both.
You're not going to do both, so you're just going to continue with this interim rate, and then ask for what's in your SIP program, or in your SIP application that's pending, but not file a new application under the pilot program that we approved last month.
Yes, sir, that's correct.
Okay, great. Thank you for answering my questions. As I stated, you know, I'm pretty strong on interim rates, and I would prefer we waited until the evaluation of the first 18 million was done, but I do appreciate you answering my questions and also your dedication to vegetation management.
Thank you.
Let me say something.
Is there any opposition to the motion?
Yes, sir.
No,
Okay, so we're going to have a roll call vote.
wait a minute, I would like to say something.
Okay,
Okay.
sorry, Commissioner Campbell has something to say.
I represent this area up there, and I can tell you there's been a big difference in our service since we've been doing this tree trimming program and whatever we're doing with the extra money. It's been a huge difference. I hadn't had the telephone call, so I'm for this. I think it's a good idea. And I think the people, like you said, the people are used to paying $2.91, and now they're going to go up to $3.05 or something like that. It's minuscule, but it's a good deal for the people that I represent.
So for roll call vote, Commissioner Campbell, how do you vote on?
Yes.
Yes. Commissioner Lewis?
No.
Commissioner Kusan?
Yes.
Commissioner Francis?
Yes.
Commissioner Scarmetta?
Yes. Matter's approved. Next item, please.
The next exhibit is number 12, which is docket number U37760. This is Louisiana Water Company's request for an extension and modification of a formula rate plan. It's a discussion and possible vote on an uncontested stipulated settlement. On October 21st of 2025, LAWCO filed the instant application seeking approval of a renewal and modification to its formula rate plan. Notice was published in the Commission's official bulletin and no interventions were received. LAWCO proposes an extension of its current FRP for an additional 3-year term, maintaining the current midpoint rate of return on equity with an earnings bandwidth based on a calculated ROE of 9 to 10%. LAWCO does request substantive and non-substantive modifications to the FRP, including adjustments to the review and the effective dates. The party reached an uncontested stipulated settlement, which was filed into the record on March 13th of this year, which authorizes a renewal of LawCo's formula rate plan for an additional 3-year term with modifications to the extraordinary cost revenue changes, additional base rate adjustment, special rate filings, and procedural deadlines. Staff recommends that the Commission accept the uncontested stipulated settlement filed into the record on March 13th of 2026.
All right. This is Commissioner Francis,
I'll make a motion to accept the staff recommendation.
seconded by Chair. Any opposition? Hearing none, the matter is approved. Next item, please.
Next item is exhibit number 13, which is docket number U37882. This is Entergy's application for a certification of generation and transmission resources and for other related relief. Is a discussion and possible vote to retain Fishman Haygood. Entergy provided notice of the instant application pursuant to the Commission's Lightning Initiative, indicating the company is going to seek certification of additional resources as well as cost recovery under its existing formula rate plan. Staff solicited Fishman Haygood, giving their experience with not only Entergy's FRP, but also their assistance in the Commission's approval of the only other certification that could have utilized the Commission's Lightning Initiative had it been adopted at the time. Based on staff solicitation, Fishman Haygood submitted a proposed budget with discounted hourly rates. Staff recommends that the Commission retain Fishman Haygood for $970,000 in fees and $28,000 in expenses for a total budget not to exceed of $998,000.
All right.
Motion to retain.
We have a motion from Commissioner Lewis to retain. Any seconds?
Second.
Seconded by Commissioner Kusan. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 14 is docket number U37882. This is application for certification of generation and transmission resources and for other related relief. It's a discussion and possible vote on a motion for procedural directive pursuant to Rule 57, so this will need 2 votes. March of this year, Entergy filed the instant application seeking resources needed to serve a substantial new load proposed for eVest, a customer seeking to locate a large hyperscale data center in Richland Parish. The application was filed pursuant to the Commission's Lightning Directive adopted at the December B&E, which provided for certain waivers of the Commission's market-based mechanism order for a proposed capacity addition where certain factors are demonstrated. The Lightning Directive also directed staff to take reasonable steps to ensure that any application filed under the directive was in front of the Commission being able to be voted on within 8 months. In the application, Entergy requested timely treatment in order to meet the in-service dates specified by the customer and requested the Commission direct the Administrative Hearings Division adopt a procedural schedule and procedures necessary to facilitate a decision consistent with the Lightning Directive. Consistent with this request for timely treatment, the company filed the instant motion into the record on April 2nd, wherein Entergy requested the Commission take this matter up under Rule 57 of the Commission's rules, and in the motion, Entergy claims that it met the 5 factors contained in the Lightning Directive and requested that the Commission direct the Administrative Hearings Division to serve as a hearing examiner and compile a record on this proceeding without a recommendation for the Commission's consideration at the November 18, 2026 Business and Executive Session. Staff does not make a formal recommendation. However, should the Commission take this matter up under Rule 57 and grant the company's motion, staff does recommend that the Commission consider the company's application at the December B&E to ensure that the Commission has the entire 8 months to make its determination consistent with the intent of the Lightning Directive. We do have a yellow card, but Commissioner Campbell, would you like me to read your motion in the record?
Commissioner Campbell, you have a motion to be read in the record, sir?
Would you read it?
Yes, sir. So this is a motion by Commissioner Campbell. Entergy filed its request for certification of generation and transmission in this docket on March 26 pursuant to the Commission's Lightning Directive. In its filing, Entergy requested the Commission establish a procedural schedule that would allow for a vote at the November 2026 B&E session. The Lightning Directive contemplates Commission consideration approximately 8 months after the filing of the application, and consideration at the November meeting will be just shy of the 8 months. To better align with the 8 months provided in the Lightning Directive, and given that Entergy must still demonstrate its eligibility under the directive as part of the proceeding, I make the following motion. I move that the Commission direct the Administrative Hearings Division to establish a procedural schedule in the docket U37882 that provides for Commission consideration of the requested relief at the December 16, 2026 Business and Executive Session. I further move that the Administrative Hearings Division serve as a hearing examiner and compile complete evidentiary record for the Commission's de novo consideration without the issuance of a formal recommendation for the presiding administrative law judge. And before we get a second on that motion, I was out of order. We need a Rule 57 motion first.
Move to bring the matter up under Rule 57. Any seconds?
Second.
Seconded by Commissioner Francis. Any opposition to the Rule 57? Hearing none, the matter is brought up under Rule 57 for consideration.
And we have Commissioner Campbell's
We
motion
have
that I just
Commissioner
read.
Campbell's motion, and we have a second from Commissioner Kusan, I believe, correct?
Oh, that was Francis.
Commissioner Francis seconded.
Okay, and before we conclude, we do have one yellow card from Ms. Elena Delora from the Alliance, if she'd like to
That's
come.
fine. Please come up, and they can make their comments.
This on the motion.
Yeah, this is on your motion, but she have a yellow card.
Good morning, Commissioners. My name is Elena Delara, and I'm with the Alliance for Affordable Energy. I'm here to request that the Commission deny Entergy's premature request to rush forward this application in November or December and remove the ALJ review and recommendation from the procedural process. The 1,200-page application alone requires significant time to review and analyze. Entergy is asking the Commission to say up front that there won't be any scrutiny or independent consideration on the record of the most transformational proposal that the Commission has ever seen. At this scale, the questions before this Commission aren't just about the risk after 20 years and what happens then. This risk is now amplified because of the sheer amount of investment that is requested for recovery. Those questions deserve independent review to determine whether the public interest is met. One of the questions that Entergy is asking the Commission in their application is to confirm that they have met the qualifications of the Lightning Initiative. But perversely, they're asking up front today to skip that scrutiny and independent review of that very question in the application. The scale of this application is so enormous, it raises the question much larger than, are these investments even prudent? Transformation like this begs us to ask questions related to grid planning, resource planning, and rate making. For example, what will be the impact of this transformation on Entergy's current generation fleet, and actually on all of Louisiana's, and on the transmission grid in such a short period of time? What is the rate making impact of the revenues expected from Meta, and how that changes the calculus of rate making for all other customers? With time for a full analysis, the Commission may discover that the benefits should be higher than what Entergy has actually promised. What are the possible effects of more fully trusting that the cost of natural gas will remain stable? If we've learned anything this year, it's that the volatility of the gas impacts folks are experiencing already, and we're only at 75% gas now. The Commission should be considering what 7 more plants will do to that exposure to market prices, and if there's anything that can be done to mitigate those effects to all of the customers. We urge the Commission to deny Entergy's request today to prematurely confirm that they've met the requirements of the Lightning Initiative and to speed up this process. We recommend the Commission consider the value of an independent administrative law judge review, which would provide a stronger record for a final decision. We support transparency and scrutiny is especially crucial here. Thank you, Commissioners.
Thank you.
Go ahead.
You want to come up? You're excused. Thank you very much.
Mr. Chairman,
Yes.
can I make a brief comment?
Yeah, go ahead.
Only in government is 8 months rushed to make a decision. And I would note that as we sit here, Louisiana is in their legislative session, which yearly ranges from 60 to 90 days, and they make decisions in less than 90 days on issues affecting each one of us every day of our lives, from energy to insurance to crime and punishment, and that seems to be enough time to make good policy in the state of Louisiana. And I think that the consideration that we're going to give this issue over the next 8 months will be enough that we're going to answer many of the questions that were just posed. And I challenge our staff and our experts to work as diligently and efficiently as possible to get those answers. And that's our charge as well.
Thank you.
I might like to say something too.
Go ahead, Commissioner.
When I was in the Senate, I often asked a lot of people, some days we passed 50 bills in one day, 50. And you sort of wonder how they got through them, but we got through it, and Louisiana's still a state. So I agree with Mr. Kuzar.
Great. Mr.
Thank you
Hand?
very much.
That's the Senate mafia. So there you go. Mr. Hand, you sure you want to do this? Okay, go ahead.
I want to be, first off, Larry Hand on behalf of Entergy Louisiana. Thank you, commissioners, for the discussion and the support. I want to be really clear for the folks who are listening to this, what is before the commission today. I don't agree with the characterization that what the commission is voting for on this motion is approving that Entergy has in fact met all of the requirements of the Lightning Directive. All that is being put before you is to proceed on the schedule, have the full discussion, the full record. We still need to prove to you, and the parties can do discovery, they can take positions. We still need to prove to you that we meet each and every one of the requirements of the Lightning Directive in order to be entitled to the exemption from the market-based mechanism process. And we are up for that task. It is, I assure you, it is in the 1,200 pages of testimony that's referred to in the exhibits, but that's why we're going to have the full process to lay that out. And I'll leave it there. I'm not going to argue the merits of the case. That's why we have the proceeding. And I will acknowledge this is a significant undertaking of the commission. It's a significant undertaking of the parties. It's a lot of work. But Louisiana is up for the hard work, and I think we're up for the benefits that will come with it. So thank you for your support.
Thank you very much.
Mr. Hand, really quickly, first I want to thank you for meeting with me and discussing this issue. And before I come to you, I just want to, a point that you made, I want to clarify with staff that under the preliminary relief, we are not in this vote certifying that Lightning requirements, the 5 requirements have been met. Entergy was just using that as an example or putting in evidence of why they believe they will meet those requirements. Thus, this motion should be accepted. Is that a reasonable understanding of what we're doing today?
That is correct.
Great, suffice.
Sorry, there's a stutter in the tape. So here you go. You got it.
Thank you, staff. Mr. Hand, just a few things, and we discussed this briefly. As you know, this has been of great interest of the public, particularly, as you know, in the preceding the intervention period ended on Monday afternoon. We do know who those interveners were. So can we just explain what consideration did we take into thinking about the comments they may make, or the ideas they may have, depending on if we go to a contested trial, whether there's a settlement or a stipulated settlement? Was that considered in asking for this motion?
I think it was, Commissioner. From the outset, we wanted to be very transparent about what our requests were. So the application we filed on March 25th, published in the March 27th bulletin, the prayer for relief in that application specified we were seeking to proceed under the Lightning Directive. In fact, we requested consideration at the November B&E. The motions changed that to December, which we are, we're fine with that. So we tried to be very transparent, but beyond that, we actually filed a separate motion in the docket seeking this relief. So we've tried to be very transparent, but I agree, we will have a full process. I would liken, what we filed in the record to show that we should be allowed to proceed under the Lightning Directive timing. That's all we're talking about is the timing. The merits will have to prove themselves out. I believe it's not legally equivalent, but I believe we have made a prima facie showing in the record that we can meet the requirements, but we still need to prove that. The other parties will have discovery rights and the opportunity to file their own positions on that before the commission makes the ultimate determination.
And thank you. And one of the, I do really appreciate the transparency that Entergy did with this motion. And unlike the last one where there were some concerns that it came later in the proceeding, that we are having this discussion up front as we are starting the discovery and pre-hearing briefs process. I will note there were some questions, and you and I discussed these, where it's not that I am opposed to us relieving and having an evidentiary hearing only. It's the fact that there's some questions that would judge whether I would approve that. For instance, if this was a contested case between our staff and Entergy and we didn't get into a settlement, or if there was contested hearings from the interveners, that would subject me to say, okay, I believe an evidentiary hearing is good, or if I see a very contested and multi-briefed positions from various parties that I would then like an ALJ to give that recommendation. So while I think I will oppose this today, it's not off of the request, it's more off of the questions that I would have to make that determination of whether or not an evidentiary hearing unfortunately just can't be answered at this part in time in the proceeding, but could be answered later on as we do discovery, as we heard pre-hearing briefs, and as we started the process of a trial. Because as you know, in the last deal, when we got to the proceeding of the hearing, we had a settlement on the table, which gave me some comfort of not having an ALJ recommendation, since we had almost all the parties there, and the other parties were able to brief that matter and then give that information to us. I'm just a little concerned about pre-jumping that, even though I do respect giving us the heads up that you would like that evidentiary hearing, but those are the questions that I have that unfortunately just can't be answered in today's motion, that subsequently could be answered at a future date.
Thank you, Commissioner. And we do look forward to working with all the parties, commissioners, to answer the questions and provide the evidence and the record you need by December. So thank you.
Thank you. Thank you, Mr. Chairman.
Great. Well, first thing, I'd just like to add in my 2 cents worth on this, that I think it's important to recognize that some folks are putting the cart before the horse on this. That it's important to recognize that the commission is not approving anything, that the game is just starting. We are looking into the analysis. But the important thing to look at is when we did the Meta project in the beginning, it took approximately 9 months. And there were lessons learned on how to do the analysis. And when we moved towards the Lightning Initiative, we figured out that there are ways to shorten that time frame. We learned the process of how we can speed up the analysis. So shortening it by 1 month is not an extreme reach. So I believe that between the consultants we have and the staff we have and the prior experience we have on the process that we've done on the regulatory aspects of this, that we can easily move this matter through within 8 months. And I think that the public will be easily protected on this. I think there is tremendous value to the public on the initial Meta project, and I think that those values will continue through the extension of this project. On a second note, and it's been suggested by Commissioner Kuso, and I think it's a valid suggestion, if the staff and the consultants see any need between now and the end of May or the end of June to a value of adding a one-day technical conference on this issue during the month of July to increase the time frame necessary to move this matter forward and get it complete within the effective 8-month period, that the commission will make itself available on a special one-day meeting in July as necessary if that can be worked out. But I do think that the fact that the commission itself does not meet in an official meeting in July doesn't mean that the consultants and the staff and et cetera will not be available to continue the work product analysis necessary to complete this task. So I think the public can take great satisfaction understanding that nothing has been approved, everything is beginning the analysis, and that the analysis will be taken with the same great consideration and study that the first Meta project was. And I think we got a lot of value for the public in that one, and we intend to get a lot of value for the public in the next one. So thank you very much. The matter's been moved and seconded. Any opposition?
Yes, sir.
Roll call vote, please.
So there's a motion on the floor by Commissioner Campbell, second by Commissioner Francis, opposition by Commissioner Lewis. Commissioner Campbell, how do you vote? On the record, he said yes.
Yeah, roll call vote, Commissioner.
I told her.
Yeah, he told me. Commissioner Lewis?
No.
Commissioner Francis?
Yes.
Commissioner Kuson?
Yes.
Commissioner Scrivetta?
Yes, matter's approved. Thank you very much. Move on to the next item, please.
Exhibit number 15 is undocketed. This is
Madam Secretary, well, that was a yes, right?
That was a yes, yes, sir. Entergy Louisiana's request for approval of an agreement with the Commission staff regarding the monetization of the 2025 nuclear production tax credits is a discussion and possible vote on the agreement between Entergy and staff. Entergy initiated these discussions regarding the proposal to obtain and realize the benefits of federal production tax credits associated with Entergy's nuclear energy production in 2025. Based on those discussions, staff and Entergy have entered into agreement regarding the monetization of those credits, whereby the realized benefits would go to Entergy's customers. Entergy proposed to staff, and after discussion, staff ultimately agreed that Entergy selling the 2025 production tax credits would benefit customers. Staff agreed, given that the full value of these realized tax credits net the transaction and administrative cost would go to customers. Customers will also be responsible for indemnities and interest if the production tax credits ultimately accepted by the IRS are less than those conveyed to the buyers. However, based on the data reviewed by staff, the potential benefits realized from the sale outweigh the potential risk. Staff recommends that the Commission approve the agreement executed between Entergy and staff regarding the monetization of the 2025 nuclear production tax credits.
Okay. We have this is a staff recommendation, and the chair votes to approve it. And seconded by Commissioner Kusan. Any opposition? Hearing none, matter is approved. Next item, please.
So I would suggest skipping Exhibit 16 since it has the executive session, and we'll go to Exhibit 17.
Let's do that.
Exhibit 17 is docket number S37783. This is Atmos Energy Corporation's request for commission approval to abandon a portion of its natural gas facilities in DeSoto Parish pursuant to General Order dated July 9th of 2008. It's a discussion and possible vote on a staff report and recommendation. This is at the request of Commissioner Campbell. On November 10th of 2025, Atmos filed the instant application, which was published in the Commission's bulletin, and no interventions were received. Atmos's petition proposes to abandon natural gas distribution facilities and associated natural gas services for 2 affected customers in DeSoto Parish. The facilities consist of approximately 6,000 feet of main that originate from EnLink's Holly pipeline system and extends parallel to Rogers Road. As indicated by Atmos, the abandonment of the facilities is necessary due to EnLink's expected abandonment of a portion of that system. EnLink's system is currently the only source of supply for the Roger Road facilities. Atmos petition further indicates that the 2 affected customers have consented to the abandonment and that the customers will be converted from natural gas to propane at the sole cost of Atmos. Staff reviewed Atmos's petition and found that Atmos has met all the requirements of the Commission's abandonment general order and have gone above and beyond, ensuring the affected customers are able to convert to an alternative fuel source at no cost to the customers. Accordingly, staff filed its recommendation on March 27th, recommending that the Commission grant the request authorizing Atmos to abandon the Rogers Road facilities, and that the Atmos files proof of services rendered effective to the customers within the docket of 30 days completion. Staff recommends that the Commission accept staff's report and recommendation filed into the record of this matter on March 27th of 2026.
I make a motion that we approve staff recommendation.
Seconded by, motion by Commissioner Campbell, seconded by the chair. Any opposition? No, hearing none, the matter is approved.
Exhibit 18 is undocketed. This is the Commission's receivership of Hillcrest Builders and Construction, Inc. It's a discussion and possible vote to move forward with a receivership proceeding at the request of Commissioner Campbell. During the 2025 legislative session, Act 257 was passed, providing the Commission a mechanism by which to place troubled water or wastewater systems into receivership. That act promulgated as Louisiana Revised Statute 45-1206 and states that the Commission may move forward with seeking the receivership of a regulated water or wastewater utility if the utility has conducted certain activities, including failure or refusal to comply with enforceable orders, judgments, or actions issued by the Louisiana Department of Health or the Louisiana Department of Environmental Quality. Based upon information received from both the Department of Health and the Department of Environmental Quality, the owner of Hillcrest Builders and Construction, Mr. John Rusty Miller, is in violation of enforceable orders for both agencies. Hillcrest Builders and Constructions is a regulated wastewater company operating 2 systems in Caddo Parish. Staff has been working with both LDH and DEQ for over a year regarding the noncompliance of Hillcrest, not only to those agencies' regulations, but also to the Commission's rules and regulations. Further, staff has attempted to work with the owner of Hillcrest Builders to find an amicable solution to his noncompliance to no avail. Based upon the open compliance orders from DEQ and LDH, the company's continued violation of Commission General Orders dated July 1st, 1921 and November 22nd, 2011, and the company's inability to rectify the noncompliance with 3 state agencies. Justifiable action exists pursuant to Louisiana Revised Statute 45-1206 to seek a receivership of Hillcrest Builders Construction, and staff recommends that the commission authorize commission staff to move forward with a receivership proceeding against Hillcrest Builders and Construction and its owner, Mr. John Rusty Miller, for its 2 regulated systems, Miller's Crossing and East Cove.
Okay, Commissioner Campbell?
This guy's given us more trouble in North Louisiana than anybody else. We've been trying to work with him. So there's only one way to improve this problem, I think. If you look at, in your book, 13 violations that he's had here. And if you had 14, he would have 14, but he has 13. So I would make a motion that we put him under receivership.
Okay, seconded, motion by Commissioner Campbell, seconded by the chair. But before taking the vote and approving it, I want to make a comment that the commission itself, up until now, did not have authority to move into receiverships, and the legislature was, recognized the viability of the commission to act in its own behalf. We used to have to look at working with other agencies to have their authority under receiverships to work with them to do this. Now the commission itself has the authority to go into civil court under our counsel to bring civil matter forward, to have receivers appointed for failing systems, to get receivers to put into place. These receivers will go in, they will expend the capital necessary to make the improvements, they will get everything going properly, and then they will return those systems to the owners with a fixed system, with working out the financials on that. So it's a big step forward for not only commission authority, but it's a big step forward for the public in moving things on a faster pace of government. So there you go. So the matter's been moved by Commissioner Campbell, second by the chair. Any opposition? Hearing none, the matter is approved. Next item, please.
Exhibit number 19 is undocketed. It's a directive to staff to implement interim rule 10A for mandatory disclosure of foreign and outside funding sources by interveners in commission proceedings, and this is at the request of the chair. Staff is directed to prepare for consideration at the earliest practicable B&E, but no later than June, a proposed interim rule 10A or other appropriate placement in the Commission's rules of practice and procedure that would require all interveners in every docket, proceeding, or matter before the Commission to publicly disclose and certify all sources of funding for their organization that originate directly or indirectly from individuals or entities located outside of Louisiana, including without limitation the following foreign nations: the People's Republic of China, the Democratic People's Republic of Korea, the Russian Federation, and the Islamic Republic of Iran, or any of the entities, agents, or intermediaries controlled by those governments. The proposed rule shall apply to both existing and future interveners and shall include, at a minimum, a requirement for a sworn affidavit or certification filed with every intervention pleading and updated annually or upon change, a statement of the percentage of annual funding for individuals or entities located or domiciled outside of the state of Louisiana, full disclosure of any grants, donations, contracts, or other financial support received directly or indirectly from the listed foreign nations or their state-linked entities during the preceding 5 years, identification of the ultimate sources of funding, including any pass-through foundations, nonprofits, or intermediaries, public filing of the disclosure in the docket subject to any narrowly tailored protections for truly proprietary non-funding information, a clear statement that failure to comply may result in denial or revocations of intervener status, sanctions, or other remedies as determined by the Commission, and an effective date no later than 60 days after adoption of any proposed rule. Staff shall model this proposed disclosure requirement rule on analogous transparency provisions in Louisiana law while tailoring the Commission's rules to the administrative context of Commission proceedings. Further, any proposed rule should emphasize that this is a transparency measure to protect the integrity of the Commission's regulatory process, the Louisiana ratepayers, and the public interest, and is not to bar participation. In proposing an interim rule pursuant to this directive, staff shall also include any such proposed rule within staff's proposed revisions to the Commission's rules of practice and procedure, currently being reviewed in docket number 36241, in order to allow stakeholder comment. This directive is issued in furtherance of the Commission's mission and the broader goal of achieving Louisiana energy dominance, and we do have one yellow card for Mr. Jackson Voss.
Okay, first off, it's a directive.
Yes.
So, any opposition to the directive?
Yes, sir.
Okay, so we'll have a vote on the directive, but in the meantime, let's hear the yellow card.
Good morning, Commissioners. I will be brief. My name is Jackson Voss. I am the Senior Government Affairs Advisor for the Alliance for Affordable Energy. We just wanted to say first, we are in full support of transparency. The Alliance thinks it's incredibly important. Over our 41 years of advocating before the Commission and the New Orleans City Council, we've been huge proponents of ensuring that the process is as transparent as possible, that people know who is involved in the process, that stakeholders have an opportunity to participate openly and publicly and transparently. I think that in that spirit, we do not have necessarily substantive problems with this rulemaking. We would appreciate, of course, the opportunity for stakeholder engagement and input to be provided, and we think that could be helpful in this case. We would want to elevate for the commissioners as they consider this and as the staff considers the rulemaking that there might be some constitutional issues to take into consideration, especially the precedent upheld in, I believe it's Americans for Prosperity v. Bronto. This is the case from California where Americans for Prosperity was seeking to protect the identities and protect the privacy of its donors from the state of California. So something for the Commission to take into consideration. Obviously, a narrowly tailored transparency process is permissible under that standard. But in general, I think the Alliance shares the spirit of this directive. We think that transparency is incredibly important, and we're glad to see the Commission take that into consideration here. We think, again, that all these processes should be more transparent.
Okay, thank you.
Thank you.
All right, Commissioner Lewis?
Just a quick question for staff procedurally. Would this is not a docketed proceeding, so would it go in the bulletin and then be open for intervention, or would this just, as I read it, would just be staff constructing an interim rule, or am I wrong on that?
No, sir. So we do have an open docket that is to revise our rules of practice and procedure. So what we're proposing, and we've done this in the past, is we issue a special order that provides an interim rule while the full rulemaking is going on. And we did this back in 2021 related to our Rule 7. And we right now have an interim Rule 7 in place because during COVID, we were having trouble doing transportation citations through the regular USPS. And so per our rules, we had to serve that way. So the Commission adopted an interim Rule 7 to allow for FedEx or UPS or some other type of method where we could prove certified, mail versus just the traditional. So we have done this in the past where we approve an interim rule while we work through the stakeholder process through an actual docketed proceeding, which is ongoing right now.
Got you. So that makes a lot of sense for me. If there is a person who now has an interest in this portion, but were not a previous intervener under that docketed proceeding, how would they be able to, or will they be able to participate, given that this was not contemplated when that rulemaking was open, even though it was brought of our overall general rules and practices of procedure?
Absolutely, they can still intervene. For our rulemakings, we rule on requests to intervene technically out of time or late all of the time. The general standard for that is just whoever is intervening takes the docket as it is on the date that they are allowed to intervene. In other words, they can't go back and try to fight something that was already decided in that docket. But absolutely, if somebody wants to intervene tomorrow in this docket, they certainly can do that.
Thank you. And so when we get to a final recommendation of that docketed proceeding, would that then take it out as an interim rule and now be part of the proceeding, or I guess I'm trying to understand the timeline here from the interim rule to when it would be subject to just part of our general rules and practices of procedure?
Sure. So the interim rule, if approved today, would go into effect. We would start the process in order for a May or June vote on the actual interim rule so we can put that rule together for you guys. After that, that would become in effect. Once the rules of practice and procedure had been completely revised and staff puts out a final rule for you guys to consider, if those are approved, then the final revised rules of practice and procedure would then take the place of the interim rule.
Thank you. Thank you for that procedural clarification. And And I would say that I am completely in support of transparency. I believe this is important. I would prefer that this be an independent docket with full stakeholder engagement, with full consideration of multiple entities, how we handle this from certain interveners versus utilities, which I think will bring a real question how they comply with this interim rule, since they are also interveners. And so while I respect and think we should handle transparency, I think there's a better avenue than an interim rule. I don't believe there's a pressing issue at this moment to do so, but that we should continue the conversations in a more deliberative process. So that is why I will be objecting to this directive today.
Okay, so require a roll call vote to approve the directive.
So Commissioner Campbell, how do you vote on Commissioner Skrmetta's directive?
Yes.
Thank you. And Commissioner Lewis?
No.
And Commissioner Francis?
Yes.
Commissioner Kusan?
Yes.
Commissioner Skrmetta?
Yes. Directive is approved and moves forward.
So here on this end, do I have 2 cents now?
Yeah.
Okay.
Go ahead, sir.
I want to commend Commissioner Skrmetta on this act, and I think it's way overdue. I'd like to ask staff.
Your mic. Can you pull it a little bit closer, please?
Can you hear? All right. You hear me okay?
Okay, yes, sir.
You might want you to lift it over a little closer. There you go.
I'd like to commend Commissioner Skrmetta on this act, and I think it's way overdue. And I was just wondering when it would be ruled here that we'd be under. How long do you think it would take for this to be over?
So I don't think it will take us long to put the rule together, especially because Commissioner Skrmetta would like us to follow already revised statutes, law in place. So I asked Commissioner Skrmetta to just give us till June to put something back to you guys. I will try to get it back in May, but June at the absolute latest.
Okay. Well, I know we've talked about the lightning speed. Now, I don't believe 8 months in Wall Street is lightning, but I'd like to put the lightning speed to this one, and I think that's something we need to get done. Thank you.
Yes, sir.
Okay.
So we are back at Exhibit 16.
Right. So in Exhibit 16, I know we have a executive session. We have an approval on a FERC matter, and that would be it, correct?
Yes, sir.
So let's do the FERC approval,
Yes, sir.
and then we'll move into executive session issues.
So under the FERC approval, it's a discussion and possible vote to ratify interventions of the Commission and RTO-related or other FERC proceedings. It's on the agenda for ratification pursuant to the scope of work approved in connection with the MISO SPP and ERSC participation. And due to those short deadlines allowed for interventions, if advance approval is not possible, the Executive Secretary can authorize the initial interventions, comments, or protests subject to ratification. Interventions were filed on the Commission's behalf for the purposes of monitoring issues related to MISO and SPP proceedings in 5 dockets. And staff recommends that the Commission ratify the actions taken in FERC docket numbers ER 26-1564, ER 26-1482, ER 26-1538, EL 26-49, and ER 26-1731.
Move to ratify the intervention into this particular FERC docket.
Second.
Seconded by Commissioner Lewis, moved by the chair. Any opposition? Hearing none, so ordered. Regarding the executive session, I think because of the complexity with the microphones in here, we can move off into another area. And staff counsel, you can take us wherever you want to take us. Did you already make plans?
Well, actually, there is a downstairs, so we could just walk down there and have it. No.
Okay, I'm not going to be a smart aleck, but yeah, okay. I was going to hold back. I'm holding back, Lauren. Okay. Move to go into do the in-ray, and we'll move into another area. But
Sure.
read the in-ray.
It's a possible executive session discuss litigation strategy pursuant to Louisiana Revised Statute 4217, and I'll take a second to Commissioners.
Second.
Thank you.
We are approved, we are going into executive session. We are out. Y'all can stay here and mingle. moves to come out of executive session. Any seconds? Second. Seconded by Commissioner Lewis. Any opposition? Hearing none, so ordered. Chair moves to adjourn. Any seconds? Second. Seconded by Commissioner Francis. Any opposition? Hearing none. This meeting is adjourned. Thank you, Alexandria.
you.